We continue our coverage of the Zanzou nightclub story. Police have warned against the circulation of the disturbing videos showing a group of men being forced to perform degrading sexual acts. But what does the law say about such videos or distributing them without consent? To help us answer this and other related questions, I'm now joined by Oosthuizen, the head of social media law at Shepson and Wiley Attorneys. A very good afternoon to you, Verley. Thanks very much for your time. What does the law say about sharing, distributing, forwarding such images?
Well, in certain contexts, it can be unlawful, and it is highly recommended that if there is video footage of this nature, you take it to the legal authorities or to the police in order to start an investigation rather than starting a social media firestorm.
In certain contexts, what are those?
Well, there may be instances where it has been given to journalists and they are reporting in the news media and they have done the necessary journalistic checks and balances. I know that journalists are held to a press code or a media code, and so they will make sure that those videos have been corroborated, that there is not an undue invasion of privacy. But when people are just sharing it on social media, you don't have those checks and balances. And you have ordinary people sharing very, very sensitive information and private information and degrading information online, and it hasn't been verified. And I think in this instance, apparently, and I'm not 100% sure, but there has been allegations that these videos are old. And when they haven't been verified by journalistic sources, then it is sometimes difficult to know whether it is real, whether it is fake. In this instance, I'm not too sure of the context of that, but rather have it verified by a proper news source than just going onto social media.
And what does the law, just for clarity, seek to do? In other words, what is the intention of the law? What is the law trying to prohibit or safeguard?
Well, there is a fundamental right to privacy and to human dignity in our Constitution. And those are very, very important rights in the Bill of Rights, and they're fiercely protected. And in terms of those rights, we've got the Protection of Personal Information Act, which is an act that has been brought about to protect people's privacy. Now, when you are reporting in a journalistic context and the appropriate checks and balances have been put into place, there may be an incursion on somebody's privacy, but it is done in such a way that it is lawful. When there are people that are not doing it in a proper context and are just merely sharing videos, you could be infringing on somebody's dignity or infringing on their privacy in an egregious manner. So it is unlawful to do that and to go against people's rights to privacy and to dignity.
And the penalties can be severe for those who willfully or not break the law, isn't it?
Yes, absolutely. There could be a criminal sanction. There could be a civil sanction in terms of a civil suit against a person, or they could approach either the Human Rights Commission for a dignity infringement, or it could be that they go to the information regulator and report that their privacy has been infringed.
I believe it also involves the Films and Publications Amendment Act of 2019, certainly according to the South African Human Rights Commission.
Yes, absolutely. And they've also got, they have to look at all sorts of content that is published online, whether it's done in the context of official films and official content, or whether it's done in terms of this type of content. And there can be fines, there can be all sorts of regulatory issues that come up in terms of that act.
How often, though, do we get cases where that even lead to a conviction, where these laws get flouted or broken?
Well, now that we do have an information regulator, it is hoped that the protection of people's privacy is going to be more jealously guarded than in the past. There's an entire regulatory body of the information regulator that deals with this. So they can issue fines and they can get involved in litigation after a complaint. Then there have been many instances where there has been successful litigation in the Equality Court. So it's not without teeth, and people can pursue their rights. However, any kind of a legal litigation pathway takes time, and it takes money, and it takes effort. And so sometimes people do lose interest.
Is there sufficient sort of case law in your view? In other words, have we been able to catch up? I mean, social media is big. I mean, nowadays it has come with lots of challenges. Are we up there in terms of the law? Has the law caught up, you know, with the social media landscape and its growth?
Well, I think that people do forget that on the social media platforms, the law is still the law. So whether you are infringing somebody's privacy on social media or whether you are doing it face to face, you know, the same kind of law and the same kind of case law and precedents would apply. And there is lots of case law relating to privacy issues that has been dealt with in the past. For example, there was a very famous case with a health minister when her health records were taken and reported on. And the principles of those kinds of cases are then used and applied in a modern day context. So there is case law available, but it does take time, as I said, and it does take money to litigate. And after the firestorm is over, sometimes people, with all of these barriers in place, do not actually want to approach the courts.
Veli, let me thank you so much for your time and for your insights.
Thank you so much for having me.